nothing that I've said, but I'll just quickly run through from the beginning. Okay, so I just started with talking about what a contract is. Okay, and we said it's a legally binding agreement between two or more parties. All right, and then we listed the elements of a contract: offer, acceptance, consideration, intention to create legal relations, capacity to contract, and legality of purpose. And then we started to look at each of the items, okay, each of these elements of a contract. The first one was to take a look at what an offer is, okay, and I mentioned specifically there that it's a clear statement of terms on which one party is prepared to do a business. And we looked at the key points, mentioning that it must be communicated, it can be revoked, counter offers terminate original offers. And that was when I asked someone to tell me what a counter offer is, and someone shared a very good example for us to be able to see what a counter offer is. And we noted there that a counter offer nullifies the original offer once there is a counter offer. So that was where I used the example of a motor vehicle. If I want to sell a vehicle for 7 million and someone wants to offer 6.2 million, if we agree on that price, that means there is a counter offer. So 6.2 million is a counter offer to 7 million naira, and so 6.2 million becomes the binding offer. Okay, it's a counter offer. And then we looked at acceptance, and we said acceptance must be communicated, must be unconditional, and then that silence is not acceptance. I guess this is where we paused when there was the issue with presenting the screen. Okay, so I was on the point of silence is not acceptance, and I was going to ask a question there. When we say silence is not acceptance, what do you understand by this? When we say silence is not acceptance, does anyone want to share?
If there's no response to an offer.
Okay, I didn't. So okay, so that we can all get it right. Can you, if you
What
raise
I'm
your hand?
saying is, if someone is ready to offer something
Okay,
and the other party there's no response from his end,
okay,
that means silence.
okay. All right. I heard someone try. Thank you very much, Mr. Adejumo. I heard someone trying to talk again. Do you want to try?
Yes, ma'am.
Okay,
If not, if both
okay,
parties are together and one person is talking that okay, this is how we are going to do, and the other one is silent about, to me, simply means that he does not agree with whatsoever agreement they want to make. Just there's no agreement between both of them. That's my own way of thinking.
okay. All right. How many of you would like to share lecture in future?
Me,
Come again, ma?
I said, how many people in the classroom now would like to lecture in future?
yes, I want to.
Okay, thank you, Mr. Adejumo. Oh, thank you, Toyosi. I see. Thank you, TJ Smith. That means everybody in this class wants to lecture in future. Oh, Mary says she wants to lecture. Okay, I was trying to ask a question where I wouldn't get a response, but I'm surprised that I got a response. Okay, that's nice. So you see, for instance, if someone walks into a room and says, maybe for a question that, for instance, there's this question of who broke who broke these plates amongst a group of people, and everybody goes silent. Okay, everybody going silent has not answered that question. Okay, how many of you will go to Kaduna tomorrow and everybody went silent? It will be wrong for the person who asked that question, okay, to come tomorrow. The person who asked that question to come tomorrow and now bring a bus to take people to Kaduna. He says, where is everybody? We're going to Kaduna. And they say, how are we going to Kaduna? He said, but I asked yesterday who wants to go to Kaduna, and everybody was silent. So that means that everybody accepted to go to Kaduna. Not at all. Everybody didn't accept to go to Kaduna. That is to say that silence is not acceptance. So we never, in the court of law, okay, The court of law never accepts silence, that you keep quiet. So they say, oh, okay, since you are quiet, that means you agree. No, if you keep quiet, it doesn't mean you agree. That's to tell you that silence does not constitute acceptance. So don't assume, it's a wrong assumption that because someone kept quiet, did you break this cup? And the person kept quiet, you now conclude that that means he broke the cup. No. The person keeping quiet may just out of not may not want to report to the person who broke the cup, but it does not mean he or she broke it. Okay, all right, let's move on. Consideration is another thing. Now, consideration is something of value exchanged between parties. Okay, something of value. Okay, value. When you say value, most times we want to maybe say something that has like a monetary value attached to it. Okay, consideration. You give something of value. Okay, and so the key point to note when we are talking about consideration is that it must be sufficient. It must be sufficient, but it does not need to be adequate. Okay, so perhaps you'll be wondering, when we say something is sufficient but it does not need to be adequate. For instance, look at the vehicle. Okay, imagine someone coming to buy a vehicle and say, okay, you put up your car for sale, you say, I want to sell this car. You probably have heard some people that sell, they say, name your price or shoot your shot with your price. They say, I want to sell this thing, shoot your shot. And somebody comes and say, I want to sell this car, shoot your shot. Let's try, let's see, if you give me a good price, I will sell it. The price may not be worth the car. But imagine someone puts up his car and someone else says, okay, I want to price it 10,000 naira. That 10,000 naira is not even enough to buy the tire of the car. Okay, so it must be sufficient. It may not be adequate. It may not be the exact 7 million, but at least if you are talking in millions, you are still closer than for somebody that is talking in 10,000 naira. Okay, now it's important to note that a past consideration is not valid. You cannot say, when I was going to buy my Toyota Corolla, I paid 5 million. And so because I paid 2 million, because I paid 2 million when I was going to buy my Toyota Corolla, now that I want to buy this Honda CR-V, I will also pay 2 million. No. Now, the consideration must be legal and possible. The consideration must be legal and possible. Somebody says, I want to buy your car and I will pay you with Bitcoin. Please, can we still hear me?
Yes, ma'am.
Someone says, I'm going to buy your vehicle and I will pay you with Bitcoin. Now, Bitcoin is legal in some countries, but in Nigeria, it's not yet considered as a legal tender. Somebody says, I will buy your car, but I will use Bitcoin to pay you. Now, it is not, that has become a situation that is not legal and possible, because in Nigeria, Bitcoin is not considered as a legal tender. Okay, are we together?
Yes, ma'am.
Yes.
All right. So next thing is that there must be an intention to create legal relations. Okay, parties must intend their agreement to be legally binding. Okay, that is, it is presumed in commercial agreements and not presumed in social or domestic agreements unless proven otherwise. All right, so I want to ask you this question. I believe that before today's lesson, you've been doing some study on your own. So my question to you today is, what is the effect of a breach of a condition in a contract? Okay, you know, a contract has conditions. Okay, we saw some of these conditions. What is the effect of a breach of condition in a... Does anyone want to try? Or let me call names.
Well, it can lead to civil, uh, maybe civil case,
Okay,
law court. Yes.
okay, all right. What can happen again? Where there is a breach of contract, what can happen? Who wants to share? Who wants to try? What do you think can happen? Let me call names. No, you must have not heard you talk today. Okay, TJ Sunimi, I see your hand, but I want Noimot to make an attempt, and then I'll come back to you, TJ Sunimi.
Okay, ma'am.
All right. Noimot, can you hear me? Okay. Yes, so I want you to try your hand on the question, okay? The question said, what is the effect of a breach of a condition in a contract? Okay, so now let me give you some time to prepare. I'll go to TJ Sunimi, then I'll come back to you. Okay, TJ Sunimi, are you there? You can please go ahead.
Yes, ma'am.
Okay.
Breach of condition can lead to like the termination of the contract,
Okay.
and it can also lead to forcing the breaching party to fulfill the obligations of the contract.
Okay. Thank you very much. Noimat, are you able to go on? Okay, Mary, all right. Mary Jo, yes, please. I see your hand.
It can lead to financial loss.
Okay, all right. Yes, where there's a breach of contract and they take you to court and you have to pay. You have to pay. Oh, yes. So thank you very much, Mr. Dejimo. Thank you, TJ Sunimi, and thank you, Mary. Okay, yes. So very good answers to that question. A breach of contract, okay? The effect of a breach of a condition in a contract. Contracts have conditions. When there is a breach, and the breach will have its effects also. Okay, let's move on and take a look at this. Okay, now where there's a breach of a condition, the injured party, okay, can terminate the contract and claim damages. Okay, I've seen cases where maybe some employees have sued their employer for a breach of contract, breach of the condition of a contract, and they've claimed damages. Some, they've had to be reinstated back to work. Some, they've been paid damages. So very good answers. Okay, another question. What is required for an acceptance to be
I can't
valid?
see your screen again.
Okay, all right, you see my screen just now. Sorry first. Okay, so while I'm bringing that up, what is required for an acceptance to be valid? Okay, what is required for an acceptance to be valid?
Well, an acceptance to be valid,
Yes.
they need an MOU, memorandum of understanding, for both parties in a legal way. To see it and read it out, the do's and don'ts, what I can take, what I cannot take. Let that be a kind of MOU between the two parties
Okay.
that will back it up with a uh, legal. Uh,
Okay. Thank you very much. Okay. Can you see my screen now, please?
yes,
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 ma'am.
yes, ma'am.
Okay. So that's the question back again. And thank you very much for that answer. What is required for an acceptance to be valid? Does anyone want to make an attempt again? An acceptance. When we say an acceptance is valid, what is required? Anyone wants to try?
When it satisfies some conditions.
Okay. All right. Mr. Dejimo, do you want to share some of those conditions with us?
Well, there are, for example, if I'm supposed to pay,
Okay.
I'm supposed to pay certain amount as part of the condition to make an offer valid, and I
Okay.
paid that amount,
Okay.
then that acceptance is valid.
Okay. Okay. Thank you very much. All right. Okay. So, when an acceptance is considered to be valid, some of the things you must consider is that there must be communication. Where you have not communicated to the offeror, okay, you have not made that acceptance valid. It must be communicated to the offeror. Okay, you know, we usually refer to offeree and offeror. Offeree is the person doing the offer now. The offeror, okay, the offeror is, you have two people involved in the contract, okay? The offeree, the offeror. The offeror is the one who has offered you. So if you have accepted a thing, you must communicate. Just like I said, someone said, I am interested. I am interested does not necessarily mean acceptance, because I am interested can mean several things. So there must be that communication. I would like to buy this for this amount. You have placed this on offer, I want to buy it. You probably see people when they do sales, they say, what do they say? They say buy as e dey hot o. They will, the first come first serve. Okay, you must communicate to the offeror. All right. Now, capacity to contract. Remember that there must be a capacity to contract when you are entering into contract. That is to say that parties must have the legal ability to enter into a contract. Remember I said to you that minors, okay, minors cannot enter into a contract. So when you enter into a contract and you enter into a minor with a minor, it's not considered a contract. It's not considered a valid contract. That is because the minor is not considered as probably in the state of mind where they can make certain decisions. The truth is that yes, in this age and time, yes, we may have some matured minors, but still the law puts that in place as a safeguard. Because where that is not in place, it means some people will take advantage of minors. You know that this one, he does not know. You know, a child, if a child wants something, they can say yes to anything. Will you give me all your food for the rest of the year if I give you this sweet? He will say yes. Did he mean it? Not necessarily. What he was interested at that point was to collect the sweet. Okay, so it's important to note capacity to contract. You cannot contract with minors. You cannot contract with mentally incapacitated people. That is to say that even if these people are not minors, okay, they are 40, they are above 18, but they are mentally incapacitated. That is, they are not in their right state of mind. You cannot contract. A person that is not in his right state of mind can make any decision. You equally cannot contract with an intoxicated person, a person that is drunk, a person that is high on drugs. And you now say, when you were high on when you had taken 7 bottles of beer, you told me that you will sell me your Prado for 5,000 naira, and you signed. So therefore, take 5,000 naira and give me your Prado Jeep. That is because such individuals lack the capacity to contract. Okay, so any contract with such parties, it is void or voidable. It is void or voidable by law. All right. Legality of purpose is another element of a contract. The purpose of the contract must be legal. It must not be against public policy. So you say you enter into a contract with somebody to sell cannabis. The sale of cannabis is not legal. Therefore, illegal contracts are considered void. Contracts that are contrary to public policy are also unenforceable. All right. I don't know if you have any questions just before I move on. Do you have any questions?
No, ma.
Yes,
No,
sir.
Okay, I heard someone say yes. Do you want to go ahead and ask your question, please?
I want to ask this question.
Okay.
We're talking about valid contract.
Sorry, I didn't
There's
hear
this
that.
contract. So we are talking about a valid contract between two
Okay.
parties.
Okay, okay,
There is this contract that binds that is, I'm talking of aviation industry now,
okay,
that if you are purchasing your tickets, there is a contract, but people don't know. There is a
okay,
terms and conditions to their tickets that you are purchasing.
okay,
And it has been there for decades.
okay,
But my question is this, why is it that so it was later when you now start explaining to them, they will start saying, oh, okay, so there is a contract like this. Me, just for me to just purchase my ticket and go. And why am I asking this question? Some of them they know, but they will still come back to you and say, why are you doing like this? You are cheating on me. You want to do fraud, you want to do that. By the time you now bring out the terms and conditions, they will not say, oh wow, where is this? But you will not know. But there is an agreement that binds both the traveler and the agency. We call it agent and the airline because they have a kind of MOU together. That if this ticket costs no show, what is no show? No show is when you miss a flight because
okay,
they are going with that seat that you have already purchased and you paid the flight. They are going like that. They are not putting anybody on that seat. They need to charge. But people will say, why? Why are they charging me? If I'm not traveling, is it their business? But not knowing that that contract is a contract between both parties. So I want to ask, why is it that when some people know things and they will still come back to you and they will ask, why is it like that? I've come across so many things like that. And even some people will say, oh, really? Okay, I will just laugh. By the time I now bring such out, they will now say, oh, okay, is that what you mean? So what can we do to, like, I personally, what can I be doing? Because they call it rules on essay.
okay, okay. Thank you very much. I want to believe that you asked this question because you work in the aviation industry, right?
Yes, I work because I face it a lot every day.
All right. And you know something, not only the aviation industry, even your bank. You know that when you want to open a bank account, I'm sure that you've not opened a bank account. Most times the account opening form, it is like in 4 pages. Hmm? The first page is maybe where you need to fill your details. The
Yes.
rest of the pages, they are the terms and conditions for opening that account. And they are
Mm.
usually small lettered. Hmm?
So that I can't read it.
And you know, we are always in a hurry.
Mm.
People don't want, they say, just tell me, where should I write my name? Where should I sign? Even the person opening the account for you will just say, just sign here, just sign here. And you too, you say, bring it, let me sign. It is maybe when something has happened later, you now say, why did you do this? Why did you do this? You now say, but you signed this form now. Didn't you read it? Eh, say, I didn't read it. I did not know. You would have told me. You know, they used to say something that if you want to hide something from an African man, you should put it in a book. That is because the reading culture is not really one of the things that we encourage amongst ourselves. But I don't agree with that statement. Okay, while reading may not necessarily come to you, you can cultivate the habit. So specifically today, I also want to tell us, if you ever have to append your signature on anything, don't allow anybody put you in a position to be in a hurry to append your signature. See, just sign here, don't worry about that thing. Tell them, say, let me take my time to read it, because it may be years to come that you will be facing the effect of that, your signature on that document. So see, come back to the air ticket now. You are saying that because you are equally an official there. So your training makes you know what is there. I tell you, how many times, even when you are booking a ticket online and they put all those your terms and conditions, you are just going down to where they say, okay, taxes, total fare amount, 120. That's where you are going to click. All the story they are saying, maybe the ones we managed to read is, how much did they say, how much luggage did they say I can carry? They say I can carry 15 kg. Okay, oh, so that when I'm packing my bag, I will pack my bag 15 kg. The rest is story for another day. So those are some of the things that we also need to encourage ourselves to do. Now you see that those people will not maybe necessarily come to that if they didn't have an issue with the ticket. If everything went smooth, journey went well, everybody is home and dry. But you see, the same way we're saying people don't read when it comes to airline too. When it comes to the airline too, refunding people when they have maybe cancelled their flight, when they have done what they should not, that's when you hear stories of months. So it is both ways really. Okay, the
Yes.
same way the airline has their terms and conditions, they will only read that term and condition when it pertains to the passenger. When it is now them, maybe you have to refund the client, you have not, you cancel the flight. I booked a flight, I needed to be somewhere for an interview, and you just came and said all flights are, the flight has been cancelled
Due to operational reasons.
due to you put due to operational reason. Only God knows, and sometimes there is no operational reason, but of course because I cannot fly myself. So at that point, that person, it may have cost the person so much. Okay, it may have cost, you don't know what it has cost such an individual. Maybe it cost the person a job that was worth millions of dollars. All your own is just that. So that person, if that person sues you, actually sues the airline, that you made me miss my flight, my flight to catch up with that interview, the person is equally right. So you see, this, when it comes to all these things, it's just that part of, we must encourage ourselves that we should not we should not be ignorant. Okay, we should read. Okay, read. Don't say, no, 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 this one is too much. How many minutes will it take you really sometimes? Because when you read too, you equally know your rights. You see, the same thing when it comes to maybe road safety officials on the road. Sometimes, because we don't know, you don't even know what is. Imagine a police officer now stops you on the highway and says, I want to check your tire, the gauge. You will do that because you are complying, because he's a police officer. But ideally, by law, is he supposed to do that? He's not a road safety official. Is the police officer is supposed to what? Ensure safety of people, of lives and property. What has now moved him to the car to check, say he wants to check that there's air in your tire? I want to check whether there's air in your spare tire, not even the tire of the car you're driving. But sometimes, because we don't know, okay, so really it's not that, it is knowing and keeping ourselves informed that is important. Okay, all right, let's quickly get back into this.
Thank you, ma'am.
Okay,
Thank you so much.
all right. So vitiating factors. Okay, we want to consider vitiating factors. Remember, please, I said to you, if you have any questions, this is the live lesson. We're supposed to be looking at, I'm expecting that you would have done some reading on your own. Okay, so please, if you have any questions, maybe from your studies, and you want us to talk about it, please ask them. Okay, so vitiating factors when it comes to a contract: mistake. When there is a mistake in a contract, it can render the contract void or voidable. Okay, misrepresentation. Okay, when there is a misrepresentation, when there is undue influence, all of this can make a contract voidable. Okay, the breach of contract occurs when a party fails to perform as stipulated. You don't perform as you say you will do, this and this, but you do not say our politicians promised us this, although we did not enter into a contract. But so many of the things they said in their manifesto, are they living up to it? Okay, so we have two types of breaches: actual breach and,
Ma, it's not a social contract. The one we
sorry
enter
sir,
with social.
don't worry, I don't want us to go to, I don't want us to enter politics in today's class.
Okay,
Yes,
ma.
it's called a social contract, but there are many things to it. Was there any, did we sign anything? We didn't sign anything. Just say, I will do this, and we say yes, we
We
voted.
signed with our voters card.
You signed
Uh,
in your voters
You
card.
sign it with our
Okay. So a breach can be actual or anticipatory. All right. The breach can be actual or anticipatory. Okay. Next, we have commercial contracts. Remember, it's commercial law we are considering. A commercial contract is a legally binding agreement between two or more parties, okay, and they are obligated to do or refrain from doing certain things. So of course the commercial contract will still have the elements of the contract itself: offer, acceptance, consideration, and all of that. Okay, what are types of commercial contract? We have sale of goods, okay, agreements concerning the transfer and ownership of goods from seller to buyer. We have service contracts, we have lease agreements, we have employment contracts. You see some people are contract, they are contract, they say I'm in a contract with MTN. Say, are you a full staff, a permanent staff? No, you say I'm a contract staff of Access Bank. Okay, people also enter into lease agreements. I cannot afford a tractor, but I can go into a lease for one. I cannot afford a house, but I can go into a lease for one. I cannot afford a warehouse for my goods, I can enter into a lease for one. Okay, formation of contracts. Please, I hope you can see my screen.
Yes, ma'am.
Yes, ma.
Okay. So when you are forming a contract, there's the need for offer, acceptance, consideration, intention to create legal relations, and capacity. Just like we mentioned the elements of a contract at the beginning. Okay, the contract must have express terms, must have implied terms, there must be conditions. These conditions to state that if they are breached, okay, the injured party can terminate the contract. Then there is also warranty. Okay, some of us, you buy equipment, they say this deep freezer has 5-year warranty on it, that if it stops to work within this period, you can return it back and they will give you, or they will repair it, or they will give you another one. And you know, that's one thing that works, especially when you hold your certificate of warranty. And that is when you are buying maybe from the dealer itself. For instance, maybe like your freezer or your fridge, you are buying a thermocool freezer. Okay, ensure that if you are buying it, you are buying it from either the factory of that company or an authorized dealer, not authorized dealer that has sold to Ikechukwu, Ikechukwu that has sold to Adamu, and Adamu that has sold to Tosin. Then Tosin is now selling to you. Then you now say, but this thing has 5-year warranty. Oh, it has stopped working. Oh yeah, Tosin, come and give me a new. Tosin will not give you a new one. But you see that warranty, if you can take it back to the original, the person you bought it from, who is the original seller, is a binding contract. Okay, I used to think that it was not true in Nigeria, but I experienced it firsthand. Okay, when I had maybe like a problem with my deep freezer, and I had to return it back. I bought it from the factory, it was Temoco, so I bought it from a wholesale agent. And when I returned it, I just felt that these people, maybe they will just do something. They repaired it, it wasn't, they gave me back, but it still didn't work. And you know, I returned it. And when I returned it, I was surprised. Next time they gave me a brand new one. Said, okay, that since they have repaired, is not, and they gave me a brand new one. Okay, so we have warranties too. All right. Termination of contracts. If there is a termination of contract, there are certain things that need to be in place. Okay, there must be performance agreement, okay, breach, frustration. Okay, so all these things, maybe in the performance of the contract, in terms of agreement, there was something went wrong. If there was a failure, that's a breach. Okay, if there was frustration, unforeseen events rendering the performance impossible, sometimes you may actually enter into contract. For instance, it's not a laughing matter, but I've seen someone who entered into a contract to sell a car, but when the contract took place, before the sale, the car was stolen. They have entered into a contract, but the car was stolen.
you see.
So that was an unforeseen event. You did not plan for it to be stolen, but that happened. So when there is a breach, there are remedies. Okay, remedies for breach: damages. It may involve monetary compensation. The court may order that there must be a fulfillment of certain part of the contract. There may be an injunction. The injunction is usually from the court. Sometimes the court gives an injunction and say this is an injunction, you must not do this. It's from the court and it must be respected because it is legally binding. Okay, so let's try the following questions to see how much we have learned so far, and I want to also know from your studies, what are the essential elements required for the formation of a legally binding commercial contract? That's one. Question 2 is that you should differentiate between express terms and implied terms in a commercial contract. And question 3 is, what are the possible remedies available for the breach of a contract? So we have 3 questions there. So I want us to try. Okay? Anyone wants to go first? Three questions. Anyone wants to go first? You can answer any of the questions, really, if you want to go first. Just tell us which number you're answering or which number you're attempting to answer.
I want to answer number 1.
Okay, thank you very much.
Number 1, we have offer,
Okay.
consideration,
Okay.
acceptance.
Okay. Okay.
And,
thank you very much. You tried. Okay. You remember more? Okay.
Legality, yes.
Okay. Okay. Thank you. Thank you very much. Okay. Okay. Someone wants to try question 2. The express terms and implied terms in a commercial contract.
Try number 3.
Okay, number 3. Okay, that's fine. What are the possible remedies available for a breach of contract? Okay, yes, please.
I will have a consequential remedy.
Okay.
We have breach of contract remedy. So we have liquidated damages.
Okay.
Injunction.
Okay.
That's what I can remember.
Okay, well done. Okay. So who wants to go for question 2?
I want to answer question 2.
Okay, I was going to, in fact, if you hadn't spoken, I was going to say, Mr. Dejimo, do you want to try? Okay, sir.
Okay, well, the difference between express terms and implied terms is this. Express terms means that the contract and the conditions are boldly written, black
Okay.
and white.
Okay.
Why implied terms means that the conditions are not written, but they are. Will I say that they are assumed?
Okay. Thank you very much. You know, when it comes to these implied terms, I used to use the example of when Ikenna, come and eat. And Ikenna now says, Mommy, can I eat? And Mommy says, eat now. You know that eat now is an implied term.
Yes.
Yeah.
If Ikenna goes ahead to eat,
Ah.
Mommy is only waiting for when they go home to knock his head and say, hey, look at you. Why did you do that? So there are some implied terms. So implied terms too may be your eye contact with your children or with your friend. Say, can I take it? And you have looked like this. They say yes. Say, we cannot eat. Yes. I mommy, you know that, and there are some children that maybe they know that thing so well. So when the mommy is saying yes, thank you, ma, I'm okay. Say, but your mommy said this. Thank you, ma, I'm okay. Because there's an implied term there.
Yes.
Without his mother writing it in black and white, he knows what to do. Okay. All right. So let me share some of my answers with you. Okay. So yes, number one, offer acceptance, consideration, legal capacity, express terms, like Mr. Dejimo mentioned, specifically stated. Implied terms is not explicitly stated. Whether they don't write it in black and white, that don't eat in your neighbor's house, don't eat when we go out, but you know it is it's registered there. Okay. Possible remedies, damages, specific performance, injunction. All right. So, in summary, in today's lesson, what we try to take a look at is we took a look at law of contracts and then commercial contracts. Okay, that was just what we've looked at for today's class. And thank you for listening. I want to ask if you have any questions. And while we're at those questions, I'll stop sharing a bit. We have a poll that we should do just before we round up this class. And please, it's important that we do this poll. It's to help us, okay? We want to ensure that we keep giving you the best. And please, I'll ask you to quickly fill. Please do well to fill to respond to the poll. Okay, just two questions is a feedback for serves as a feedback for me. It serves as a feedback for management too. Okay, to know areas we need to. I just want to confirm. Can you see the poll, please?
Yes, ma'am.
Okay. So please
Yes, ma'am.
let's do well to fill it. We want to see that we keep giving you the best and we keep getting better. And while we're at that, please, I want to know if you have any questions, maybe on your personal studies, your private studies. Any questions, please? Okay,
I
please
have a
let's do
question.
well. Okay, yes, I see you.
Please, on this peer-to-peer assessment, I
Okay,
think I'm lost completely. I marked somebody, I marked somebody, but on my own question, I'm still seeing something on animals or something like I'm totally confused. So I just have to leave it like that. I don't know what.
okay. So because it's peer reviewed, what it means is that when it's peer reviewed, it's like among your peers like this. But as much as possible, um, you try to do it anonymously. So I don't want Mary to know that she's reviewing Mr. Adejimo's work. Maybe because Mr. Adejimo is Mary's friend. So Mary is anything Mr. Adejimo says is correct, and that may not be the case. Okay, so that's why it's for you to also see what your other colleagues are thinking about the same thing, just like we have been discussing today, everybody with their own different opinions. Okay,
Yeah.
so that is why that's why that peer review takes place. So okay,
Yes,
so
I know, but
graded.
for me now, not to for somebody not to mark my own work.
No, don't worry,
I hope it
don't worry.
doesn't count on my C.
No, no, no. It is not
Okay,
graded. No, it's not.
okay,
Because
okay,
if it is graded now, if we use it and Tijesu Mnimi says, I don't like this Mary, I don't like the way she talks. Anything she said there is just zero. No explanation for the zero. I will not know. So it's not, it doesn't form part of your final grade, no. But it
okay,
helps you to see other people's ideas, see what they're also thinking about the same
okay,
subject matter. Okay?
okay. Thank you so much.
Okay. All right. I don't know. Do we have any other questions? We are almost at the dot of 5.
Bye, ma'am.
No questions. But I hope you understood at least a bit from what we
Very,
discussed.
very good.
Yes,
Okay.
ma'am.
Okay. All right. Okay, so I look forward to seeing you again. And please don't forget we have office hours where you can call in if you want to. You can register for if you have any questions you want to ask before we have our live lessons. You don't have to wait till the live lesson. Okay. So I look forward to seeing you again in our next class. And if you have any questions, please do well. We can meet at our office hours and then we discuss. Okay. So
Thank you.
then keep learning and keep reading to become a good lawyer. Like Mary Jo was saying, we should not overlook certain things. Okay, so we know our rights well. Okay, it helps us too. Okay, don't ignore things. They are small. If you need to get a pair of glasses, get them and read them. Okay, don't just say yes to everything. You may be signing away your property, not knowing. Hmm? All right. Have a good evening. Thank you.
Thank you, Mama.
Bye bye, Mark.
All right. Thank
Thank
you
you
very
so
much.
much.
Bye.
Yeah.
Okay.
Thank you, Mom.
All right. Thank you. Okay. Thank you, Noemot. I didn't hear your voice. I'm hoping I'll hear it next time. Oh no, it's okay. No problem. If you understand and it's clear, it's fine. Okay.